The Anti-Monopoly Law of China is the People's Republic of China's major legal statute on the subject of competition law. It was passed by the National People's Congress in 2007 and came into effect on 1 August 2008. The Anti-Monopoly Law of China in a narrow sense refers only to the Anti-Monopoly Law of the People's Republic of China, passed by the National People's Congress on 30 August 2007. And implemented as of 1 August 2008. In a broad sense, it refers to the anti-monopoly legal system of China, including not only the A-mail, the post-A-mail ancillary legislative, and legal documents for the purpose of enforcing the A-mail, but also all pre-A-mail legislative and administrative documents with an anti-monopoly nature, as well as regulatory or administrative enforcement, private enforcement and judicial procedures. The definition used here refers to its broad meaning. It is commonly recognized that the legislation of the anti-monopoly law in China was initiated in August 1987 when an A-mail drafting team was set up by the former Legal Affairs Bureau of the State Council to formally proceed to draft the A-mail. Prior to this, however, and following the economic reforms and opening in China, the State Council had already promulgated the provisional rules on expediting economic alliance as early as 1 July 1980, aiming to break down territorial blockades and departmental barriers. This was followed by the State Council provisional rules on the launching and protecting the socialist competition on 17 October 1980, aiming to step-by-step reform the existing economic management system and actively promote and protect smooth competition. A third document, the State Council Rules on Further Expediting and Protecting Socialist Competition, was released on 23 March 1986. These three documents served as the earliest form of anti-monopoly law and were intended to break down the historical planning of economic monopolies in the pre-1980s era and to promote the initial and basic market economy and competition. Since August 1987 onward, the significant milestones of anti-monopoly law legislation in China are as follows. 1988, the drafting team produced the Anti-Monopoly and Anti-Unfair Competition Provisional Regulations. The 30th of August 2007, the 10th NPC Standing Committee passed and promulgated the A-mail the 1st of August 2008. The A-mail was put into enforcement Hawaii vs. IDC cases Ribang vs. Johnson & Johnson case Tencent vs. Qihu 360 case. The basic structure and framework of the Anti-Monopoly Law of China up to date include the following legislations and the implementing legal documents. Legal applicable exceptions. NDRC rules on administrative enforcement procedures against price monopoly. SIC rules on administrative investigation and sanction against cases concerning monopoly agreement and abuse of dominant market position. SIC rules for prohibition of monopoly agreements. SIC rules for prohibition of abusing of dominant position. Guidance on the definition and determination of the relevant market. MOFCOM, PBOC, CBRC, CSRC. SIRC rules on the calculation of business revenue for the notification of financial institutions. Concentration. MOFCOM guidance on the notification of undertakings. Concentration. MOFCOM guidance on the documents for the notification of undertakings. Concentration. MOFCOM guidance on the procedures of the anti-monopoly review of undertakings. Concentration measures on the notification of concentration of undertakings. Measures on the review of concentration of undertakings. Provisional rules on divestiture of assets or business from undertakings in concentration. Notice on the establishment of national security review on foreign investors' merger with or acquisition of domestic enterprises. MOFCOM's interpretation of the measures on the notification of concentrations of undertakings and of the measures on the review of notified concentrations of undertakings. MOFCOM regulations for the implementation of the security review system for mergers with or acquisitions of domestic enterprises by foreign investors. MOFCOM working guidance on regulations for the implementation of the security review system for mergers with or acquisitions of domestic enterprises by foreign investors. MOFCOM interim rules on the assessment of the competitive effects of concentrations of undertakings MOFCOM measures on the investigation and sanction against SIC. Rules prohibition of abuse of administrative power to exclude or restrict competition price law. Tendering and bidding law provisions on administrative sanction against illegal price practices. Provisions on the procedures of administrative sanction against illegal price practices. The Supreme Court judicial rulings on several issues for the application of law concerning the proceeding of unfair competition civil cases MOFCOM guidelines for anti-monopoly notification for merger with an acquisition of domestic enterprises SIC guidelines on anti-monopoly enforcement in the field of Intel.